Hello friends, welcome to Lawyer's Kingdom. Let's talk about the rights of an employee as per Indian Constitution, punishment, steps, remedies, and procedures. The Indian Constitution provides several rights and protections for employees to ensure their fair treatment and well-being in the workplace. Let's explore some additional rights of employees as per the Indian Constitution. Right to freedom of speech and expression. Article 19(1)(a) of the Indian Constitution guarantees the right to freedom of speech and expression. Employees have the right to express their opinions and raise concerns about workplace matters without fear of reprisal or discrimination. Employers cannot penalize employees for exercising this right. Right to equal pay for equal work. Article 39(d) and Article 43 of the Indian Constitution ensure that employees receive equal pay for equal work. It prohibits discrimination in payment based on gender, ensuring that men and women receive equal compensation for performing the same or similar work. Right against sexual harassment. The Sexual Harassment of Women at Workplace, Prevention, Prohibition, and Redressal Act 2013 provides protection to employees against sexual harassment. It mandates the establishment of internal complaint committees in workplaces and outlines the procedure for filing complaints. Employers who fail to address complaints or take appropriate action can face penalties and legal consequences. Right to maternity benefits. The Maternity Benefit Act, 1961 grants female employees the right to maternity leave, paid leave, and other benefits during and after pregnancy. It also prohibits the termination of employment during maternity leave. Employers must comply with the provisions of this act, and any violation can result in penalties and legal action. Right to grievance redressal. Employees have the right to seek redressal for any grievances they may have regarding their employment. They can approach their employer or the appropriate labor authorities to address issues such as non-payment of wages, unfair treatment, harassment, or any other violation of their rights. The labor authorities have the power to conduct investigations, impose penalties, and provide remedies to the aggrieved employees. When an employee faces issues or violations of their rights by their employer, they can take certain steps to address the situation. Here are the steps an employee can take against an employer, along with the relevant forums and sections under Indian law. Communication. The first step is to communicate the issue to the employer, either verbally or in writing, clearly explaining the problem and seeking resolution. This allows the employer an opportunity to rectify the situation. Grievance Redressal Committee. Many companies have an internal grievance redressal committee to address employee complaints. Employees can approach this committee to report the issue and seek resolution. The procedure for filing a complaint and the composition of the committee may vary from one organization to another. Labor officer. If the employer fails to resolve the issue or if there is no internal grievance redressal mechanism, the employee can approach the labor officer of the concerned region. The labor officer will investigate the matter and may initiate conciliation proceedings to resolve the dispute amicably. Labor Court or Industrial Tribunal. If the issue remains unresolved, the employee can file a complaint or a case with the Labor Court or Industrial Tribunal. The appropriate forum depends on the nature of the issue. These forums have the authority to hear and adjudicate labor disputes. Sections of relevant labor laws. The specific sections of labor laws that may apply to the employee's situation depend on the nature of the issue. For example, payment-related disputes, Sections 7 to 14 of the Payment of Wages Act, 1936. Unfair dismissal or termination, Sections 2A, 25F, and 25 grams of the Industrial Disputes Act, 1947. Sexual harassment at the workplace, Sections 2, 3, 4, and 9 of the Sexual Harassment of Women at Workplace, Prevention, Prohibition, and Redressal Act, 2013. Maternity benefits, Sections 5 to 13 of the Maternity Benefit Act, 1961. Example: Ria, an employee at XYZ company, has been facing consistent non-payment of her wages for the past 3 months. Despite several discussions with her employer, the issue remains unresolved. Frustrated with the situation, Ria decides to take action. Here are the steps she can follow. Communication: Ria sends a formal email to her employer outlining the non-payment issue, the amount owed, and the dates of the pending wages. She requests immediate payment and sets a deadline for resolution. Grievance Redressal Committee: since XYZ company has an internal grievance redressal committee, Ria submits a written complaint to the committee, providing all relevant details of the non-payment issue. She attaches copies of her previous communication with the employer as evidence. Labor Officer: despite Ria's efforts, the Grievance Redressal Committee fails to address the issue. She decides to approach the Labor Officer of her region. Ria visits the Labor Office, submits a formal complaint, and provides all the necessary documentation, including her employment contract, attendance records, and payment history. Conciliation Proceedings: the Labor Officer initiates conciliation proceedings by summoning both Ria and her employer. During the conciliation meeting, the officer mediates discussions between the parties to facilitate a resolution. If an agreement is reached, the employer agrees to pay the pending wages as per the agreed upon terms. Labor Court: in the event that conciliation fails, Ria decides to file a complaint with the Labor Court. She engages a labor lawyer who assists her in preparing the necessary legal documents, including a formal complaint outlining the non-payment issue and the violation of her rights under the Payment of Wages Act, 1936. Section of relevant labor law: Ria's complaint cites the relevant section of the Payment of Wages Act, 1936, specifically Sections 7 and 14, which address the timely payment of wages and the consequences of non-payment. Please like and share the video and don't forget to subscribe. Thank you.